Define evidence and explain its scope. Revised rule on evidence. Rule 128, Section 1. Evidence is the main sanctions by these rules of ascertaining in judicial proceeding the truth respecting a matter of fact. Revised rules on evidence. Rules 128, Section 2. Scope. The rule of evidence shall be the same in all court and in all trial and hearing, except as otherwise provided by law or this rule. What are the three kinds of evidence? Briefly explain each. Rule 130, Section 1. Subject as evidence are those addressed to the same of the court when an object is relevant to the fact in issue. It may be exhibit to examine or viewed by the court. Rule 130, Section 2. Documentary evidence. Documentary as evidence consist of writing, recording, photograph, or any materials containing letters, words, sounds, number, figures, symbol, or their equivalent of or other mode of writing expressions offered as proof of their content. Photograph include still picture, drawing, store image, x-ray, film, motion picture, or video. Rule 130, Section 22. Testimony confined to personal knowledge. Witness can testify only to those facts which he or she known of his or her personal knowledge, that is, which are derived from his or her own perception. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of the different kind and characters tending to prove the same points. It is a piece of evidence that may be derived from various sources but proves a common point. Cumulative evidence is additional evidence of the same kind and character tending to prove the same point. This is really the accumulations of similar evidence that is derived from common sources. What is prima facie evidence? Is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue its support. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, the prima facie evidence will be enough basis from the court to rule in favor of the party that offer the prima facie evidence. Declaration. Section 37. Dying declaration. The declarations of dying persons made under the consciousness of an impending death by be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. What about statements returned as part of the res geste? Section 44, part of the res geste. Statement made by a person while a startling occurrence is taking place of immediately prior or subsequent thereto under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res geste. So also statement accompanying an equivocal act materials to the issue and giving it a legal significance may be received as part of the res geste. Declaration. Section 37. Dying declaration. The declarations of dying persons made under the consciousness of an impending death by be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. What about statements returned as part of the res geste? Section 44, part of the res geste. Statement made by a person while a startling occurrence is taking place of immediately prior or subsequent thereto under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res geste. So also statement accompanying an equivocal act materials to the issue and giving it a legal significance may be received as part of the res geste. What is the order of examinations of individual witnesses? Briefly define each. Rule 132, Section 4. Order in the examinations of an individual witnesses. The order in which the individual witness may be examined is as following. Rule 132, Section 5. Direct examination is the examination in chief of the witness by the party, presenting him or her on the fact relevant to the issue. Section 6. Cross-examinations. Upon the terminations of the direct examination, the witness may be cross-examined by the advised party of any relevant matter, with sufficient fullness and freedom to test his or her accuracy and truthfulness, and freedom from interest or bias, or the revise and elicit of important fact bearing upon the issue. Section 7. Redirect examination. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answer given during the cross-examination. On redirect examination, section on matter not dealt with during the cross-examination may be allowed by the court in its description. Section 8, re-cross-examination. Upon the conclusion of the redirect examination, the advised party may cross-examination the witness on matters stated in he or her redirect examination, and also on such other matter as may be allowed by the court in its description. Section 9. Recalling witness. After the examination of the witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant or withhold leave in its discretion as the interest of justice may require. Briefly explain what is judicial affidavit. The GR seeks to recognize the ever-increasing caseload in the country, brought about the high number of cases filed each day, and the relating procedures observed. The JAR or GAR also seek to address any lost translations and interpreting the testimony of the witness if the testimony was translated from local language into English. An offer of compromise in criminal cases in unimplained admissions of guilt. What are the two exceptions? There are only two exceptions where compromise is not admissible as implied admissions of guilt in criminal cases. 1. In quasi-offenses or act defined and penalized under Article 365 of the Revised Penal Code. Riskless imprudence and simple imprudence or negligence. 2. Those allowed by law to be compromised, their usual example, are found in the Revised Penal Code, particularly Article 266D of the Revised Penal Code. Compromise that the victim agreed to marry and indeed got married to the accused in the rape case, or if the compromise was made before the filing of the criminal complaint. In order for evidence to be admissible, it must be relevant and competent. When evidence relevant, when its evidence competent under Rule 128, Section 4, evidence is relevant if it has a relation to the fact in issue, as to induce belief in its existence or non-existence. From the rule where gathered, there are two components of relevance. First, relevance evidence has a relation to the fact in issue, if either it's a relation between the evidence and the fact in issue, then the evidence is material. Second, relevant evidence can lead us to relevant in the existence or non-existence of the fact in issue. If the evidence support or believe that the neglected fact exists, then the evidence has probative value. Competence in addition to relevant admissible. Evidence must also be competent under Rule 128, Section 3. Evidence is competent if it is not included by the law or this rule. If a piece of evidence is disqualified by the law or the rule of court, then it is not competent and will be inadmissible. Is leading question when it's allowed. Section 10. Leading and misleading question. A question which suggests to the witness the answer which the examining party desires is a leading question. It is not allowed except on cross-examination. On preliminary matters, when there is difficulty in getting direct and intelligible answer from a witness who is ignorant and child of tender years in a feeble mind or a deaf mute, of an unwilling or hostile witness, or of a witness who is an advised party of an officer, director, and managing agent of the public or private corporations, or of an partnerships or associations which in an adverse party. What is the misleading question? A misleading question is an which assumes as true or fact not yet testified to by the witness, or contrary to the which he or she has previously stated is not allowed. Is circumstantial evidence sufficient to sustain a conviction? Section 4. Circumstantial evidence. When sufficient circumstantial evidence is sufficient from convictions of A. There are more than one circumstance. B. The fact from which the inference of derived as proof, and C. The conventional of all the circumstance is such as to produce a convictions beyond reasonable doubt. Distinguish burden of proof from burden of evidence. Rule 131, Section 1. Burden of proof of burden of evidence. Burden of proof in the duty of the party to present evidence on the fact in issue, necessary to establish her claim or defense by the amount of evidence required by law. Burden of proof ever shift. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to the other in the course of proceedings depending on the exigency of case. What is the standard of proof necessary in civil cases? Rule 133, Section 1, Preponderance of evidence. How determined in civil cases? The party having the burden of proof must establish he or her case by preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issue involved lies, the court may consider all the fact and circumstance of the case, the witnesses' manner of testifying, their intelligence, their mean and opportunity of knowing the fact to which they are testifying, the nature of the fact to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses. Through the preponderance is not necessarily which the greatest number. Criminal cases, Rule 133, Section 2, proof beyond reasonable doubt. In the criminal case, the accused is entitled to an acquittal unless he or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does it not mean such a degree of proof, including quality of error, produce absolute certainty, moral certainty only is required, or that degree of process which produce convictions in the unprocedent's mind. Administrative cases, briefly defined is Rule 133, Section 6, substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established. It is as supported substantial evidence or the amount of relevant evidence which a reasonable mind might accept as adequate to justify conclusions. Substantial evidence is a less quantum of proof required by the rule. It is applicable in administrative actions which, unlike judicial actions, do not include conducting full-blown trial and are meant to be concluded with greater speed. An administrative body can render a decision of a basis that the evidence presented is evidence which the reasonable mind might accept as adequate to justify a conclusion. This means that the evidence can make a reasonable persons believe that the allegations have occurred. Define what are public documents. Rule 132, Section 19, classes of documents for the purpose of their presentations in evidence. Documents are either public or private. The written official act of record of the sovereign authority, official bodies and tribunals and public officers, whether of the Philippines or of a foreign country. B. Document acknowledged before a notary public except last will and testament. Document that are considered public. Document under testes and convictions which are enforced between the Philippines and the country of source, and the public record kept in the Philippines a private document required by the law to be entered therein. How do you prove and present the court private document? Rule 132, Section 20, proof of private document. Before any private document offered as authentic is received in evidence, its due executions of an authenticity must be provided by any of the following means. A. By anyone who saw the document execute or written. B. By evidence of the genuineness of the signature of handwriting of the maker, or by other evidence showing its due executions and authenticity. Any other private document need only be identified as the which is claimed to be. The original documents rule state that when presenting a document as evidence, only the original is admissible. What are the four exceptions? Section 3. Original document must be produced. Exception. When the subject of inquiry is the content of a document, no evidence shall be admissible other than the original document itself, except in the following cases. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offer. Or B. When the original is in the custody or under the control of the party against whom the evidence is offered and the letter failed to produce it after reasonable notice. Or C. When the original consent of monoraeus account or other document which cannot be examined in court without great loss of time, and the fact so to be established from them is only the general result of the whole. And D. When the original is an public record in the custody of the public officers or is recorded in a public office. Who can become a witness? Qualification of witnesses. Section 20. Witnesses, their qualification, except as provided in the next succeeding sections, all persons who can preserve and preserving can make their own known perceptions to others may be witnesses. When in a extrajudicial confession sufficient to sustain a conviction. Section 3. Extrajudicial confessions not sufficient ground from convictions. An extrajudicial confession made by an accused shall not be sufficient ground for convictions unless corroborated by evidence of corpus delicti.